previously acknowledged the cap on deposits for residential properties. If you're required to drop higher than a sum of 2 months' rent in the escrows, your landlord can use it for back rent or repairs in the first year. Then we say this is unfair and that's certain in PA, and that's the rule. What I'ma do in this rhyme for you is show you how to use it when filing suit. Now I'ma use the case of VS Management versus Guy, which happened back in 2017 to examine this. The facts of which put landlord against students who came to him from China, from college, trying to find him a place to live. To honor one of the students was this lady named Shua, who paid landlord some moolah to save the space, but when the kids couldn't move, landlord refused to refund it to her, which awful students in our brochure disputed. That's the reason they sued him. The dollar amount that they pursued is $5,785. That's a small claims in Pennsylvania. And Shua filed the first case in MDJ, and landlord sued a month later. Suits were consolidated before the court, which favored the landlord in both cases, but that ain't it. See, Shua appealed the common pleas where he filed for breach of contract in violation of the rule that's our topic. Read deposits to 5511A of the Landlord Tenant Act. The sum she claimed was not too much rent, in fact, but 3 exactly. And that she claimed was an unfair practice, which per the statute called the UTPCPL establishes that she's owed treble damages. 3 times the cash it is, but landlord on appeal wasn't having it. He had defenses. The claim for breach and some other things he named in pleadings, which landlord says means he's got indeed a right to keep the deposit. In common pleas, when cases do not exceed a dollar figure of 50,000, we must now proceed to arbitration, which was compulsory. And in this part of the story, both parties went before a 3-lawyer arbitration panel. And whatever the panel rules, if you should lose, you still appeal and argue anew in front of a common pleas judge for sure. In this case, a jury. The landlord lost once at R, but then a jury gave a ruling that Shua and the students should win. They were awarded the deposit they paid to him in full. Then the judge gave treble damages. Landlord was mad, I guess, cause after this he moved for a judgment notwithstanding this trial verdict, but the court overruled it. So landlord appealed again, so a higher court could review it, cause he ain't learned. The case went to superior court and was affirmed. The reason we will surely discern. No, on appeal, his management said damages were handed out in error, and that can happen. The standard that the court now has to use for this question here on review is whether judge below abuses discretion. They viewed abuse, it wasn't. And this is true to the landlord. It took exception to the sum of damages granted here, cause 2 months rent per statute is the limit by law. And here too is exactly what landlord collected in all. Well, he argued that in court. What does the evidence show for this question? Did he mess up as a yes or a no? They've established rent was $19.95 for 1 month. The deposit was $3,990. Wait, whoa, just $3,000? I thought they paid you $5,785. Yeah. What happened to the rest? Judge, we're talking about prepayment. Prepayment? Not the deposit. Prepayment for the last month. No, they gave you $1,000 and change, said the court to the landlord, not just prepayment. Rule 511A says that you violated, no matter how you name it, as long as they paid it. Per 511B to secure the lease, then you're gonna need an escrow account for the fees. Well, that sounds like security, that's what the court believed. To argue anything else, well, it's just pure deceit. So disingenuous still, this ain't the end for this, cause now the question is still if treble damages, it can't exist. Landlord says they can't because his practices are unfair or deceptive kids per statute, but the court disagreed, just giving reasons of what this here opinion fees is underlying all these. That these kids are all Chinese coming from overseas who barely read English, and it's all as it seemed to try to squeeze them. That's what the court believed. They pointed things first. They saw the lease security was supposed to be 1 month. That's what it reads, but they asked for 2. Landlord said the reason it had to do with the foreign status. Ooh. And that's the reason he had to lose. But there's a whole slew of tactics used that can't confuse the average dude, much as this pack of students from China. The next reason why the court denied landlord here is it's the bullhead. The fact the kids will forfeit all of the hard spent cash if students didn't sign a contract. Landlord waited till they paid before he stated this fact. Plus 2 days is all he gave him to review the whole lease. That's not in the native language, so that wouldn't be easy. So it shouldn't be a shock that students couldn't agree within the 2 days. Landlord showed his whole bootay, cause next when the kids said they simply were not moving, the landlord told the aunt they've got to pay all of the rent that would be due in the lease. Ooh, that was sleazy and truly egregious. The UTPCPL is the statute of issue, which has a catch-all provision that says the one definition of unfair practices is deceptive acts to create a likelihood of confusion. That's what our landlord was doing per this court ruling. His acts were found unfair or deceptive, what gave the trial court discretion to make his damages treble. That's what they did, because what Landlord did was egregious, although the court didn't need his type of behavior to reach it. That's what they said. That Landlord got one win in this ruling. Here is it pertain to sure, and the false claims he made to her on this, the court overruled her, because the one said the two at least wasn't sure. The lease pertained to only the student. She's no consumer, but otherwise the landlord's the loser. In this review of the trial court, abuse isn't found.